It's now a half minute after the hour of 8 o'clock. Beautiful Tuesday morning, the 29th of June, 2021. And it's now time for the legal landscape. And let me just tell you right up front that we will take your calls or your messages. You can call us if you have a question on the subject we've been telling you about all morning that we'll be looking at, the common misconceptions about the registered land title. You can call us on 876-906-9557, or you can send us a WhatsApp message if you have a question about registered land title. The number to send the WhatsApp number would be 876-383-1166. So, let me just tell you before I introduce my guest. In a recent article, the Housing Agency of Jamaica, HAJ, stated that it issued more than 9,000 land titles under the National Land Titling Program to date. The HAJ intends to register more than 7,000 additional titles in favor of residents all across the island. Now, for many property owners in Jamaica, this is the first time that they can show firm proof of ownership over their respective properties. These titles may then be used as collateral for individuals or businesses to obtain loans or to conduct business backed by a real asset. But how secure is a registered land title, you might ask? Can it be defeated by a third party who claims to also have an interest in the same property? Well, these and other questions will be answered inside of the legal landscape right now. We introduce our very special guest. She's an attorney at law and a partner at DunnCox Attorneys. We're joined by Mrs. Trudy-Ann Dixon-Frith at this time. Good morning, attorney.
Good morning.
And how are you today, Mrs. Dixon-Frith?
I am fine, thank you.
Oh, thank you so much for being a part of the program. Armed with all the information we need on the matter of the registered land title and some misconceptions we'll be focusing on this morning, right?
Yes.
First of all, I want to ask you, what is a registered title for land?
So under land ownership in Jamaica, there are actually two types of land. There is what we call unregistered land and registered land. So registered land just means that the land has been registered under what we call the Registration of Titles Act, and that a certificate of title is issued to the landowner.
Okay. That is what it really means.
That's what it really means.
Okay.
So you have a paper in your hand.
Mm-hmm. That you can hold on to. It's a very important bit of paper too, eh?
Yes.
How can a title be obtained for unregistered land?
Okay, so for unregistered land, what applicant can do is make an application under the Registration of Titles Act, and the Act actually sets out how you go about this. One, there is a form that is filled out, and that applicant also swears what we call a statutory declaration. Mm-hmm. Almost like an affidavit, but you go before a judge and you swear not a judge, I'm so sorry. You go before a justice of the peace, mm-hmm. and you swear to the truth of what you're putting in that statutory declaration as to how you come about ownership of the land, mm-hmm. either through you purchased it or you inherited it under a will, or you've occupied the property undisturbed for 12 years. Any one of those things can satisfy the registrar of titles that you own the land and that she should issue a certificate of title for it in your name.
Okay. I want us to now look at the rights of an owner of registered land.
So the rights of an owner, the primary foundation is that it's what we call indefeasible. So the owner of a land can use his land anyhow legally that he wishes. That is, he can occupy the land, live on it, rent it, he can sell it, he can mortgage it. So he can use that land any way he wishes.
Mm-hmm. Okay. Interesting question coming in. Can the registered title be set aside? Is the question I'm being asked to ask you.
And a lot of people think that it cannot, and that's actually one of the misconceptions a well-known law professor, Professor Codellini, Gilbert Codellini, I'll quote him.
Yes.
He says, all titles are relative in the sense that the person's title, including paper title, is good insofar as no other person can show better title. And so the answer to that is yes. A registered title can be set aside, and it can be set aside in two main circumstances in Jamaica. There are other circumstances,
yes,
but two main circumstances is one for fraud, if a fraud has been committed, and it can also be set aside for what we call adverse possession, what a lot of people will know or call, quote-unquote, squatter's title.
Yes.
So it can be set aside in those two primary circumstances.
But you mentioned fraud. Who must commit the fraud to allow for it to be set aside?
Yes, so that is another misconception. A lot of persons think that once a fraud has been committed, it means that the original title will be restored, which is not the case. The person who commits the fraud for a new title to be set aside must be the person in whose name the title has been issued.
Mm-hmm.
So I'm going to give you an example.
Please do.
If you have what we call a bona fide purchaser without notice of the fraud, in other words, that's how the Registration of Titles Act coins it. In other words, I purchased property not knowing that the person who I bought the property from is a fraudster, not the true owner.
Mm-hmm.
But I paid my money for it. The law protects that purchaser.
Okay.
And so the person who had the property originally will lose the property, because in court you have to prove that purchaser knew and was a part of the fraud.
Okay. That's interesting. We're getting a lot of information here on the subject, the common misconceptions about the registered land title being provided by Mrs. Trudy-Ann Dixon-Frith, a partner at DunnCox. I have another one for you here, Trudy-Ann. What are the requirements to obtain title by adverse possession and defeat registered title holder? So,
adverse possession is fairly simple. All you have to establish is 12 years undisturbed occupation, and the paper title owner can be ousted by who we would call a trespasser. That's all that has to be shown. So here is the other misconception. Not because a registered owner, the title owner, visits the property, it means that it interrupts the trespasser's occupation. Not because there's an acknowledgement by the trespasser that the title owner is the paper owner, means that the title owner is protected.
Mm-hmm.
So all that is required is 12 years undisturbed occupation to the exclusion of the paper owner.
Mm-hmm.
So in certain circumstances where the paper owner sees a trespasser on his land, he needs to take immediate steps to have that person removed.
Oh.
Because if you sit on your rights, you can lose your title to your property.
Yes. I tell you, I've found the discourse very, very interesting and informative today. Unfortunately, we're out of time, so we can't even ask more questions. We have enough time, though, before you go, to thank you, first of all, and to also ask you, do you have a did you know hashtag for us today?
No.
And if so, what it is? No?
I don't know. I'm so sorry.
All right. Well, you've said enough, and we thank you for all that you shared with us this morning. Useful information that I'm sure that the listeners will be able to. They're much more informed today because of your presence. Thank you so much.
Thank you so much for having me.
It was our pleasure. Have a good day, Mrs. Trudy-Ann Dixon-Frith, a partner at DunnCox, attorneys at law, and she helped us out on the subject of the common misconceptions about the registered land title. 10 and a half minutes now past the hour of 8 o'clock. That's the time. We're on a break. We'll come right back.